Hello, good afternoon. My name is Oluwatosin Isaac, and today this is another session of Ascent Litigation. I want to welcome everyone. Thank you for staying tuned. Thank you for always joining this interesting session. So today we have another topic to discuss. If you were with us last week, we discussed the enforcement of judgment. That is on ascent litigation. We've been talking about what to do after judgment, how to enforce judgment, and today we continue with that. So we've talked about what to do after judgment and how to enforce judgment. And last week I remembered I was the one here. And last week I said that we talked about the writ of FIFA or FIFA. Writ of FIFA, yes. And we explained that when a judgment is given, and this writ of FIFA is an application the judgment creditor makes to the court to seize and sell the judgment debtor's properties in order to pay his debts. I mean, if a monetary, I think I remember discussing the types of judgments where we have declaratory judgments and monetary judgments, mainly executionary judgments, where you have to carry out something or do something. So in a situation whereby the court orders that somebody should pay up his or her money, his debt, and the person is unable to, the judgment creditor, that is the person in whom judgment was given in his favor, can come to the court through his counsel and apply to the court for a writ of FIFA. Writ of FIFA is what? Simply asking a court to seize and sell the properties of the judgment debtor in order to pay off his debts. We talked about the fact that you can only make the application first, target the application towards his movable properties. Movable properties now, that is chattel, except his beddings and apparels and his tools for work. Yes, I remember that also. And I also discussed the fact that if you've made an application towards his movable properties and yet you're unable to balance, you're unable to pay up, or the money realized from the sale of his property is unable to satisfy the judgment debt, then you can make an application with the permission of the court, move to his immovable properties and sell, all for the purpose of the judgment creditor enjoying the success of his litigation. Now that is one way to enforce judgment, monetary judgment. Now today we are talking about another way, and that is Garnishee proceeding. So we want to discuss briefly what Garnishee proceeding is and how it's being done, what it's all about, and how it's being done, the process, the procedures, and everything. And I want you to know that whatever process, whatever procedure, whatever thing that is practiced, it is always backed up by the law or the rules of courts. So things are not just done. They're not just done for the sake of doing it. If the court gives a judgment, there are rules, there are laws applicable to ensure that judgment is being enforced and is enforced legally and outrightly. So first of all, one thing you should know about Garnishee proceeding is that there must be a judgment. Now we're talking about how to enforce judgment. That is how to make, in a layman term right now, how to make a judgment come into effect. The courts have said this is the judgment of the court, this is what a party is supposed to do, this is what the other party is supposed to do. Normally, humanly speaking, we might not do anything. The judgment can be there and nobody will do anything. That is why these laws are in place to ensure that the judgment takes effect. So when I mention enforcement of judgment or enforced judgment, I'm still talking about judgment taking effect. Let us see what the court said. Let us see it in reality. It's not just about saying it right now, except when it's declaratory. So you must bear in mind that there must be a judgment of the court, a court of competent jurisdiction, which brings about three different kind of parties. Now there is a judgment. We have the judgment debts. Remember, we're talking about monetary judgments, right? So when we're talking about monetary judgment, it means there is a debt to be paid. There is a debt in sum of money, any amount of money. So in Garnishee proceeding, we have the judgment. There is always a judgment. There is always the judgment debt, and there are three parties involved right now. The judgment creditor. The judgment creditor is the person that the judgment was given. Now I'm breaking it down in a layman's terminology. I don't want to use legal terminologies because we might not understand. I mean, we want everybody to understand, right? So I'm actually breaking it down into the simplest way you can understand. Now there is somebody called the judgment creditor. The judgment creditor is the person in whom the judgment was given in his favor. He is more like the claimant in the case, and he won. Okay, the court has ordered that he is claiming the sum of 50 million naira. Let's use that as our case study. He's claiming the sum of 50 million naira, and the court is saying, yes, having gone through your claims, your weaknesses, everything, blah blah blah, yes, you are entitled to 50 million naira. That is the judgment creditor. Now we have the judgment debtor. The judgment debtor is the person in whom the judgment was given against. That is, he is the one to pay the 50 million naira. The court has said, judgment debtor, you are owing the sum of 50 million naira, so you must pay so and so the judgment creditor 50 million naira. That is the judgment debtor. Then there is a third party. The third party is called Garnishee. Now the third party is called Garnishee, and I'll be telling you the role of a Garnishee. Now I want you to understand that writ of 5A is different from Garnishee. In Garnishee there is always a third party. Writ of 5A is just the judgment debtor alone. His properties, just target all his properties, anything that he has, target it and sell it off. But when it comes to Garnishee proceedings, there are three parties involved. We have the judgment creditor, we have the judgment debtor, and we have the Garnishee. But generally, based on what I've said so far, we can say that Garnishee proceeding is just a judicial process that involves enforcing monetary judgment by attachment of debts due or according to the judgment debtor, which form part of his property available in execution. What am I saying? Garnishee proceeding is when you are actually, let me put it this way. It is when I told you there are three parties involved, right? So Garnishee proceeding is simply that this person is owing me money, but there is somebody or someone or something that is in custody of his money that I can actually ask him to pay. Did you get that? Now let me give you a scenario. A, B, C. A, B, C. A is saying that B is owing him, right? B is owing him. B is saying that, yes, I know I'm owing you, I'll pay you. But I have money with C. C can be a bank. C can be an employer. C can be anybody, anything and anybody. So C is saying that I have money with B is saying I have money with C. Go and meet C. Do you understand? Meet C to pay you. So you're actually collecting the debt from C. So C is the third party. C is the Garnishee. Now C is not was not part of the suit. The first suit, right? The first suit that brought about the old judgment. C is not part of it. It just comes like an independent party to come and settle the debt of B. I hope it makes sense. I hope I'm making sense. I hope I'm actually making sense. So A is saying B is owing me money. B is saying that I have money with C. Go and meet C. In fact, sometimes I say it might not even be with the permission of B like that, because nobody wants to pay them, nobody wants to release his money. But if you know that B has money with C, you can just apply to the court. That's the Garnishee proceeding, right? And it's a proceeding. So you apply to the court. My lord, B, we are aware that B has money with C, and C, we want to garnish C to pay the debt. You don't need anybody's permission for the court's permission. That's just it. Because on a norm, like I said, human beings might not want to pay the money. So that is Garnishee proceeding. So C is more like an independent party that is not part of the suit, but you can actually clear off the debt from C on behalf of. It's just like C clearing the debt on behalf of B, like that. And like I said, it can be a bank, right? Everybody keeps money in bank, so you can actually garnish the bank of B. B is using First Bank. That means First Bank is the Garnishee. So you are garnishing what? You are garnishing C to pay the money. Now, I hope this explanation is clear. And like I said, this procedure is backed up by the law, and the major law that the major judgment enforcement rules is the Sheriffs and Civil Process Acts. We also have judgment enforcement rules, and we also have the rules of the High Courts. These are the laws, even constitution part. These are the laws that actually guide judgment enforcement in Nigeria. So this process, the Garnishee proceeding, is prescribed by in section 83 to 92 of the Sheriff and Civil Process Act. So how does Garnishee proceeding works? I've explained we have the judgment creditor, which is also the garnisher. We have the garnisher and the garnishee. You understand? The garnisher is that's law for you. The garnisher is the judgment creditor, and the garnishee is the independent party, not B now. Do you understand? Not the judgment debtor. Garnishee and garnisher. So the garnisher, which is the judgment creditor, we garnish the garnishee. Do you get it? I hope you do. So I've explained who the judgment creditor is. It's also known as the garnisher. I've explained the judgment debtor, and I've also explained the garnishee. Now, in Garnishee proceedings, there are 2 stages. Remember, you want to garnish someone that was not part of the suit, someone that was not part. He doesn't even know anything. It's just like you're just going to somebody, whoa, your friend is owing me money, or you pay me. You understand? It's that kind of thing. So he's not even part of the suit in the first place, but you want to collect money from him. How is that possible? So there are 2 ways to go about it. 2 ways, 2 stages. There are 2 stages to go about it. Remember, if you are doing something like this, you definitely need the permission of the courts, and that's where the whole proceedings comes in. We have the Garnishee order nisi, and we have Garnishee order absolute. Okay, you know that B has money with First Bank, right? You know that he's using First Bank, and you know that he has some reasonable amount of money. You have, even if it's 1,000 naira, you still garnish it. Just garnish. Oh, you know, you get to court and you see so many garnishes just for one person. He's using First Bank, Union Bank, Access Bank, and you got to ask how much is in the First Bank account. It's 1,015 naira. How much is in his Union Bank account? And maybe the person is owing like 1 million naira. Let's say like 1 million naira, and the First Bank account is 1,000 naira. And you just see so many banks like that they are garnishing, or those was one person. Oh, that's what makes it interesting, Sha. Okay, so I said there are 2 stages. We have the first stage is for the Garnishee order nisi. You get a Garnishee order nisi, and the second stage is for the Garnishee order absolute. Now, what is the Garnishee order nisi? The Garnishee order nisi is simply you applying to the court to get an order to invite the garnishee to court to come and state whether he can settle the debt or not. If he have any reason whatsoever, or he has the capacity, or he has a reason to settle the debt. Like I said, it can be a bank, it can be a person, it can be an employer, it can be anybody. So if it's a bank, for instance, you are applying to the court that, okay, you are aware that he uses First Bank. Apply to the court to get an order nisi. The order is to mandate First Bank to come to court. Of course, First Bank, like the bank, cannot come to court. Definitely a representative. So the person will come to court representing First Bank and say that, okay, fine, yes, Mr. So and so uses First Bank and he has so amount of money in his account, and if there are no encumbrances, so he doesn't have any issue, well, they can actually let go of the money to pay off his debts. So it's just a way of letting the third party have a say. Remember I told you that it was not even part of it in the first place. So that order is letting the third party know that, see, B is owing me, and we know that he has some money with you. So come to the court and come and tell the court whether it's true or not, and why you think you cannot pay him or you will pay us. Do you understand? So that is just the summary of the whole order. So it's just an opportunity for the third party, the independent third party that was not a part of the suit, to be informed that this is what is happening, and come and tell the court why the order should be made or should not be made. They might have reason why they cannot release the money. They have reason why, or even if it's a person, the person has to come to court and say, he doesn't have any money with me. Oh. The money that is with me, I've used it to settle so and so. He doesn't have any. You understand? Just for the person to come and give reason. So that is for the order nice side. Then the second order, after the person has done this, now the judgment creditor, through his counsel, gets this order by filing an application, a motion ex parte. A motion ex parte is just, you don't need the other party. You just come to the court to ask for permission of the court for the court to grant the order. So once the court grants the order must be signed. Now, a motion ex parte means that you are the only one that can come to court. The other parties do not need to come to court to come and hear your application. So since you are the only one, once the court grants your order, you have to file and serve the two parties, the judgment debtor and the Garnishee, the order, informing them that, see, the court has given order why First Bank should come to court to come and state the reason if he can pay the money or not. So it has to be served. Then the second stage, once that stage is done, once you've done that and you've served, the second stage is called for you to get the Garnishee order absolute. So the order absolute is made at the second stage on the return date, given at the first stage if the Garnishee fails to attend court or does not dispute the debt. Now, the first stage, you have filed an application for a Garnishee order nisi. The court has granted the order. You have served. You served, and after the given date, it's 14 days if I'm correct. 14 days for them to reply. So if after 14 days nobody comes to court, the Garnishee did not come to court to come and say anything, then the court will give an order absolute. Or perhaps the Garnishee comes to court and he comes to give reason. He did not dispute it. Like, he did not dispute it. Like, if I First Bank, okay, yes, he has money with me. He has money with our bank, and we know that if he doesn't have any issue, this is money, we can let go of the money. Understand? So if that's the case, then the court will now grant an order absolute for him to use the money to clear his debt. Because on the normal day, the human being will not want to release that money. So some people will have money, some people will actually have money in their accounts, and they will claim they don't have money. That's the beauty of this Garnishee proceeding. Go to the bank, Garnishee, come to court. The court will say, okay, fine, the amount in his account is 2 million, this. He has 2 million naira. It can settle the debt, right? Or if you cannot settle the debt, they garnish another thing again. Probably people that managing his properties, he has properties, people are managing it, or if he has other bank accounts, they can garnish everything. So an order absolute is like the final order, a final order to get the money. So another absolute is just simply saying, okay, if the Garnishee did not come to court, they did not respond to the order, they did not come to court to come and state reason why they cannot garnish or why they should, or perhaps they come to court and they did not dispute anything, then an order absolute will be given, and the judgment debtor account will be garnished. So basically that is it. But the aim, I want you to understand that the aim of this is for the judgment creditor to enjoy the success of his litigation. I mean, this is someone that was claiming something, he went to the court for redress, and he got judgment. So every litigant should enjoy the success of litigation, which is judgment. So the aim is for the judgment to be satisfied. The aim is for the judgment to take effect. Because I'm not just speaking to the air and that's just it. No, it has to take effect, and that is the purpose of Garnishee proceeding. So basically that is all about Garnishee proceeding. It's a means by which judgment is enforced. Garnishee proceeding denotes that the judgment debtor himself is a creditor to another, and that the judgment creditor has to obtain an order of court that the debtor pays the judgment creditor by the instrumentality of attaching the debt. So where the judgment creditor has garnished the debt standing to the credit of the judgment debtor in the hands of the garnishee, upon the service of the order nicer from the court, the garnishee becomes a custodian of the whole of the judgment debtor's fund attached. So once the orders have been given, the garnishee is now like the custodian of the whole judgment debtor's fund. He is the one, he has the fund in his account. So until all the debts are cleared, he is the custodian of the fund. I hope you've been able to learn something about garnishee proceeding. Like I said, the aim is for the enforcement of judgments and for judgments to take effect. So next week, I do hope you join us for another interesting episode on accent litigation. My name still remains Oluwatosin Isaac. Don't forget to like, don't forget to share, don't forget to comment, don't forget to ask your questions, and don't forget to invite more people to come and learn. Remember, ignorance of the law is not an excuse. We learn every day. So do leave your comments, leave your contribution, or maybe you have experiences, and let's learn together. So until I come your way again, same time, same day,